Good morning, or should I say almost afternoon. It's noon for you guys over there in New Mexico. How's everybody doing today? I'm going to have Terry, who's going to be monitoring the chat at all times. So if you have any questions or anything there, feel free to drop them in. I know Terry just shared that Robert's Rules cheat sheet. So one of the most common questions I get when it comes to board meeting stuff is like, how does Robert's Rules of Order actually apply to my board meeting? And I'm going to go more in depth in the actual presentation. But like, if you were to strictly follow Robert's Rules of Order, you would be so caught up in trying to follow them that you wouldn't be able to have an actual board meeting. And so there is that cheat sheet as something that you could use to reference. However, I mean, you don't have to necessarily use every single one in the middle of a meeting. But like I said, we'll talk about that a little bit more. So for those of you that don't know me, my name is Marcus Martinez. I'm an attorney over here at File Fotheringham. I've been with the firm for 4 full years. I just started my 5th year here at the firm. I've been practicing as an attorney for a little over 5 years here in Arizona and over 4 years in New Mexico. So I'm originally born and raised in Santa Fe, New Mexico. I moved out over here for law school and I love the winters too much. So I've decided to stick it out here ever since. Of course, I suffer during the summer. So my dream career would be spend all my summers over in New Mexico, spend all my winters over here in Arizona. So who knows, maybe that might end up happening one day. So the real reason that we're here is to talk about meetings. However, I have to give you my little pitch about the firm. So here at VF Law, we are a multi-state HOA condo law firm. Our main office is actually, let me pull out my laser pointer here.
Sorry, I'm still not sure about.
No, Siri. If everyone can see that a little bit. Okay, good. So our main office is actually based out of Portland, and we have attorneys that are licensed in all of the states that are orange. So we do have attorneys in Washington State, Oregon, Idaho, California, Nevada, Utah, Colorado, Arizona, and New Mexico. Me, as well as one other attorney, Quentin, is also licensed in New Mexico. So this actually helps a lot when it comes to our clients, because we're actually able to see in real time how all of these different HOA and condo law issues develop. So I get to see what happens when a certain statute or a certain process is enacted over here, let's say in California, let's say in Oregon, and then I get to see how that interacts with Nevada, Utah, Arizona, and usually some mixture of the two pops out in New Mexico. So it's been really great because I get to see it, like I get to see the law actually moving in real time, but I also get to see what things work, what things don't work, and I'm able to bounce ideas off of attorneys in all of these different jurisdictions to say, this was better to do this, or this was easier to accomplish this goal. We tried this and this is what happened. So you, as all of my New Mexico clients, you actually get the benefit of not only my years of experience, but all the years of experience of all of the attorneys in the firm. We are, like I said, a one-stop shop for everything and anything HOA. So we do handle a lot of collection work. It's probably like about half of the stuff that we do for our New Mexico clients. Our firm also handles construction defects. We do HOA litigation matters, including insurance defense. We will review contracts if you ever need us to, whether it be for a vendor or for an insurance policy or a management company, whatever that might be. We do handle some landlord-tenant stuff, although it doesn't happen too often because the association doesn't always own real property. It'll own common area, but nobody's technically living in the common area, or at least they shouldn't be. So landlord-tenant does come up every now and then, but not as often as you think. Document enforcement, of course, if you have covenants that are being violated or restrictions that you need help enforcing with, I can help with that. I mentioned our insurance defense. We also help with fair housing claims if you're dealing with any of those. And we can also assist with any document amendments. We had a really crazy case come down in Arizona. I hope it doesn't get picked up in New Mexico, but to prevent that from ever actually happening with one of my clients, I can not do what they did here in Arizona. So that way we don't have to worry about that. But like I said, we're a one-stop shop. If Amazon is the one-stop online place for all of your needs and Walmart is the one-stop brick and mortar place, we are your one-stop shop for anything and everything that your HOA could possibly need. So the real reason why you came here today is to talk a little bit about board meetings. So me as an attorney, I can tell you that in law school, I spent 1 hour of one class in one semester talking about covenants and HOA restrictions, condo covenants, everything like that. So when I came into practice, I had never been to an HOA board meeting. I'm not a homeowner in an HOA, so I never had the opportunity to serve on a board, and I didn't have the opportunity prior to coming here to actually attend a board meeting. So this class was recommended to me by one of the directors at a management company, and they stated, like, can you just give a refresher course for managers and board members on what it is to have a board meeting? And so I thought of the idea, like, these are the things that I wish I knew before my first board meeting after attending board meetings for a little over 5 years. And so keep in mind, if you ever feel that you need an attorney present at one of your board meetings, you can always reach out to me. I'm happy to attend them. I attend probably about 2 to 3 a month. Some boards will have a meeting every quarter. Some boards will have a meeting every month. It just depends. Like, it depends on your governing documents. It also depends on how frequently you actually need the board meetings to occur. But if you ever need me to attend, I'm always happy to go, and I can always assist, or I can always give you tips on what you're doing, what you could do better, things like that. That's what this course is also designed for. So what I'm hoping to accomplish today is I'm hoping to go over all the key components of what you need for your HOA board meeting. I'm going to go over what you need to do in preparation, things that you can do to help you conduct a better board meeting, and then anything that you need to wrap up or close your meeting as well. So first and foremost, what you need to know about your board meetings when you're getting ready for them is that all board meetings are considered open meetings under the New Mexico HOA Act. The Condo Act is so the HOA Act is this statute here, the 47-16-17. The Condo Act is 47-7CA, which references to meetings. The Condo Act is not as exhaustive as the HOA Act, but a lot of the times in a lot of jurisdictions, you'll find that they're both almost read as the same or read together. So whatever applies to the HOA Act, you can probably assume that that's going to apply to the Condo Act. Of course, there are things that separate them in different parts of it. Like the Condo Act is there's a lot more sections to it than the HOA Act. But when it comes to open meetings, you can pretty much apply this to both your condo meeting as well as your HOA meeting. So when I say that all board meetings are open, what I mean by that is that if you ever have a quorum, whether that be a quorum of your owners or a quorum of your board of directors, that is a meeting that needs to be noticed. And if that meeting is not noticed to the rest of the community, any action taken in that meeting is not valid. So if you are this can get a little tricky, which I'll go into later about email communications, but pretty much if you are a board member and you're meeting with other board members in a quorum, unless you have given notice of that meeting, do not discuss HOA business. That is the best way to do it. Like, we want our board members to still be friends outside of the board itself. So clearly you could go over to John or Jim's house and you could have a drink and you can, be friendly as neighbors. But if you're going to someone's house and 4 of you are on the board, and let's say there's 5 people on the board altogether, you would have a quorum. So do not, in my recommendation, do not discuss HOA business, because that may be interpreted as a meeting. And if you have a meeting and you didn't give notice, any action taken will be invalidated. So that's what I mean when it comes to open meetings. So if for any reason that you do have to close the meeting and go into executive session, there are 5 reasons listed in the statute. 1 is for legal advice from an attorney. 2 is for pending or contemplated litigation. 3 is for personal health or financial information of an owner. 4 is personal health or financial information of an employee of the association. And 5 is personal health or financial information of a contractor of the association. So if any of those reasons come up in your open meeting, those can be closed and go into executive, or you can wait for your executive to talk about them. It's not preferred to speak about those specific things in open meeting for various reasons. There is also a secret 6th reason why you would go into executive session, and that is for appeals from owners. So when an owner receives a violation for violating a covenant, they receive a violation notice. In that violation notice, it states that an owner may request a hearing in front of the board to dispute the violation. By default, those are to be done in executive session. However, the statute does say that an owner can opt to do it in the open. So your default is take it to executive. If an owner wants to, they have to tell you that they want to. They can do it in open. In the years that I've been practicing, I've only had 2 instances where somebody has requested it be an open session. I can tell you that in both of those instances, it probably worked against the homeowner when all of a sudden you're bringing it to everybody's attention that you're violating the governing documents, because everybody that's there at the meeting is presumably following the governing documents. So they're like, why are you interjecting me into your dispute with the HOA? That's my own personal opinion. Of course, sometimes there are times when it is necessary to bring it to everybody else's attention. Maybe you feel that you're being singled out for some reason. But typically, by default, send it to executive. And then if they opt for the open, then you can send it to open. So before your meeting, you have to always give notice. So this goes along with the open meeting law, as well as what your governing documents will state when it comes to meeting notice. So the type of notice that you're going to send will change depending on the type of meeting that you're holding. In general, there are 3 different types of meetings. There's an annual meeting, which under the HOA Act states it has to be held at least once every 13 months. There is a special meeting, which is outlined in your bylaws. And if you do happen to have a special meeting, you must go to the HOA Act for the process and procedure of providing notice. So the HOA Act says specifically, if you're holding a special meeting, you need to state the time, date, location. You have to state the purpose, and it has to be delivered to owners within 10 to 50 days before the meeting, regardless of what your governing documents say. So the purpose of why you're calling the special meeting, that comes from your governing documents. The process for providing notice, that comes from the HOA Act, if that makes sense. The final type of meeting, and probably the most common, is your regular board meeting. So the only notice requirement for a regular board meeting is that the notice needs to be provided at least 48 hours in advance of the meeting. And unless there's a longer period in your governing documents, and it needs to be done by a conspicuous posting. So that can either be done by a posting in like a common area, it can be sent by a mail notice, or it can be posted on like a social media or something. And those are all laid out in the statute as well. So before you get started for your meeting, you need to make sure you have notice. Depending on what type of meeting you have, that will tell you what notice you're providing. So what I always like to give for my board members and for my managers is this is very important. Before your meeting, do whatever you can to prepare. So this cuts both ways. Managers need to do everything they can to get their boards ready. And usually my managers will provide a packet with everything that they need for the meeting. And my board members, I mean, I know this is a volunteer position. I know that this is time that you're taking away from the other things that you could be doing, but you absolutely need to go into your board meetings prepared to discuss any and everything that might come up. So for managers, what I like to say, please prepare your board members with packets for all the information they need for the meeting. Include agendas, include drafts of board resolutions, proposals, anything like that. Financials beforehand, perfect. So that way the board can actually speak about them intelligently to the owners and address any questions. If there are bids, let's say you're looking for a new landscaper, let's say you're looking for somebody to help with concrete or something, bids that are to be reviewed and voted on, any prior meeting minutes, because one of the first things you have to do in your meeting is to actually approve the prior meeting minutes. And any other requests by board members, usually that could be ranging from anything from, did you look into this specific insurance thing that I asked you to? Did you look into this particular invoice that we got? So, I mean, managers, do everything you can to get your board ready for their meeting. Board members, far too often, they do not review the packets before the actual meeting. So please go through your packets. Your manager spends so much time getting this packet together. The least you can do is go through everything so that way you're ready for your board meeting. We want you to at all times, we want you making informed decisions, especially about the action items that we have on the agenda. So be ready to speak about topics and be ready to address questions from owners. However, I always like to give this little caveat. If you do not know the answer to a question in open meeting, do not speculate. If you do not know something, I do not know is a perfectly acceptable answer, or I need to gather more information. Don't ever feel like you're being pressured in a meeting to answer somebody's question just because they're in front of you. So if you don't have the answer or you don't feel like you're going to give the correct answer, it is totally acceptable to say, I will get back to you. I need to speak with this person. I need to speak with this person. I need to talk to the attorney. And then you can always follow up at the next board meeting or through an email or whatever it might be. So like I said, just don't ever get pressured in that situation, which I think we're going to see here in a minute in one of our videos here. I have a couple videos just to show about when board meetings tend to go a little sideways. So let's see here. So this video is 7 minutes long. I'm only going to show about the first 5 minutes of it. But tell me, managers and board members, if you have ever actually been a part of a board meeting that went this way.
Before we start, I want to make a couple things clear. This is not a board meeting. This is an HOA compliance meeting. That's the only thing we're going to consider today.
Oh, I bet you that's all you want to consider.
That's all this meeting is. We have 3 meetings scheduled, one at 10:30, one at 11, and one at 11:15 with the homeowners who are not in compliance with this particular issue. If at that time, any of those homeowners would like to have the audience removed so it's a private hearing, they may do so, because that's what this was designed for. It was a one-on-one meeting to not embarrass anyone or cause any problems. It's that simple.
You mean to save yourselves from being?
We're not involved.
Oh, bull. You guys have ruined this neighborhood.
All right,
Okay, we're gonna start with
Meeting's
the
good.
very first one.
I didn't know the meeting was in order.
the meeting is in order.
But Donna, I
First
thought
thing-
you said it wasn't a meeting.
First issue today,
Can I make a point?
yes,
Does it have to do with the stopping?
has had to do with this meeting.
No question, yes. Can we introduce the board
Sure,
and explain why we do not have a president?
sure,
Sure.
And why the community wasn't made aware that we don't have a president anymore?
sure.
Same, Laura.
That's a
Same.
topic that is not.
Not on the
part of-
agenda.
We'll
today.
introduce ourselves.
And just so you know,
Yes, sir.
we have approached, because we were hit with that as a surprise as well.
Okay,
And we have approached some other people seeking somebody in the board to be on the board and do that. And if we find someone that wants to do it, we're more than welcome to add them to the board.
well, I was under the impression that the board
Let's start our
doesn't
meeting.
handpick
We're
their
not-
personnel.
That's not the
Let's
topic.
start
Not
our
the topic
meeting.
today, Dan.
All right.
But
second
we
note-
don't handpick. All we did was put it out there that we'd lost a member of the board.
Who got that we lost a member of the board and
Yeah, we did.
it was open for,
And we didn't do it in an email.
We didn't do it this last.
We
time.
just found out about it, but
Yeah.
that's not on the agenda today.
We need to start the meeting.
Yes, the
okay,
meeting,
please introduce the board, and secondly, all meetings are required to be tape recorded.
Great.
great,
Okay,
They are not required,
they're not required,
but we,
Okay.
but we'll be happy to do so. And oh, by the way, if you do record it, and within a given day, don't erase it, you're in violation of state law.
Oh, goodness.
We've already been to the attorney on it, but anyway, we're not discussing that.
No,
The me-
we know the
Per
state
the
laws.
law, and one thing I want to say.
Excuse me,
Per the law, I would like
Let's
to say
stop.
something.
we haven't even
First of
started.
all, I do work for an attorney.
What's your
Second of
name?
all, Priscilla, I go by Lynn. Second of
Priscilla?
all, you board members,
Oh,
you being on here, you're supposed to.
So
be voting.
just me watching this right now.
That is the law.
that is.
Not one person in
goodness.
this area has gotten a ballot to vote anybody in.
As we have told you.
I have been here 8 years.
Wait a minute,
Let me
listen.
finish. Let me finish and then you guys can talk.
Whew.
Not at one point in time has anybody got a ballot here to vote you in. It's a 1 year. Check with the attorney. Check with the attorney for the homeowners. You are to be voted in. You have a 1 year term. Not at any point in time does anybody here, did you get a ballot to vote for anybody? Did you get a ballot? No, nobody's got a ballot to vote, to say, let me finish.
We're letting you finish.
Stop interrupting her, will you?
I would like to clarify something that might make it more understanding for you.
I do know.
No, it may make it more understanding, believe me.
Are you an attorney?
Since day one,
Oh, we're a homeowner. just
since
like
day,
you.
listen to me, since day one of this association, there's never been an election.
Okay, okay, I'm gonna stop you right there. Okay. Goodness gracious, that board president. I mean, he's trying. I mean, he's trying really hard, but so many things are happening right there. So when he first called the meeting to order, I mean, he didn't establish a quorum. We don't know what type of meeting this actually was. It kind of sounds like the board was coming together to discuss violations for homeowners, which is typically done in executive session anyway, right? I don't know what state this actually was being done in. He did mention something about recording at the meeting. So in New Mexico is actually a one-party consent state. So that means if one person party to the conversation decides to record, that is a totally legitimate recording. So to put it in perspective, in California, they're a two-party consent state. So you need the person who's recording as well as the person who's being recorded to consent to the conversation. So in New Mexico, if somebody wants to record your board meeting, there's not really much you can do to stop them. It is good to be aware that you can be recorded, right? So you can prevent maybe an issue like this where things start to go really sideways. In my experience, if somebody comes to a board meeting, they don't usually come to tell you that you're doing a fantastic job. They usually come because they're upset about something or they want to make their voice heard about something. So it sounds like from this little short clip, there's some animosity in the association between who was elected to the board, were they elected, who knows. There's attorneys being thrown around. There's the president not having control of the meeting itself. There's talk of litigation, right? The homeowner was saying, have you spoken to my attorney? Are you an attorney? What has been going on? And then on top of that, you have the board president making statements in the middle of open meeting on a recording stating that the association has never done an election. I mean, like, if that is actually true, that's one thing, but we still don't want to point that out in the middle of an open meeting when a perfectly acceptable answer would have been, that is not what we're here to speak about today. I need to gather more information. I'll have to get back to you on that. Like, that would have put a lot of that to rest. Another thing to keep in mind, like if you are a board president or you're a community manager that's in charge of keeping this meeting on task, you can always sort of push it to, that would be great to speak at during the open forum session of our meeting. Or you know what, that's a great concern. We're actually pushing for this particular action item on the agenda. Can we speak about this later at this time? And then, if they become increasingly disruptive, which has occurred in some of the meetings I've gone to, there is always the option to just shut the entire thing down, where if we're not being productive, if we're not actually using our time to take care of the association business, then there's no reason for us to keep trying to just fight with each other in open meeting. So remember that is always holstered for you as a board member, that you can always just close the meeting altogether. All it takes is a simple motion, and then you vote to close, and that's it. And then whatever was on the agenda to get done, it gets pushed to the next meeting. I mean, and that's probably the easiest way to deal with it. One of the benefits for New Mexico lately is everything has pretty much gone to Zoom meetings. So if somebody does start to become disruptive in that type of way on a Zoom call, you just have to mute them, or you could always kick them from the call. I would not kick an owner from a call on a Zoom unless you have given them numerous warnings first, and try just muting them. Because of the open meeting law, we don't want to appear like we're excluding people without, going through at least some sort of notice showing that we did everything we could to work with them and be reasonable. We don't want to just be excluding people out just because we feel they're being disruptive. I have had some meetings where things have gotten so hostile between owners and board members that we have had to hire security. So if you're a manager or you're a board member, if you feel that the disruption is interfering with your ability to do your board member duties or your manager duties, us as an association, we have a duty to actually go in and hire somebody to help keep the peace, so to speak. So we've had off-duty police officers, we've had security guards. It's definitely something, it's definitely a drastic final step, but it is something that we may have to do. It just depends on the situation. So with that being in mind, here are the things that board could have done to have a much better start to their meeting. So on the day of the meeting, you've already sent out your notice, you already reviewed all of your packet and everything to get ready for your meeting. Here's what you should do. follow your agenda to help keep that meeting on track. Beforehand, let's, put someone in charge. Who is going to run this meeting? Is it the president? Is it the community manager? Is it the vice president? Whoever it is, we want one person to be addressed as running and keeping everything on track, almost as the chair of the meeting. Typically, your bylaws would say that is the president, and usually I see that fall on the president, but that's their job. Their job is to keep everything in order, and if order goes completely out the window, you shut the whole thing down. So the most typical process when you're following an action item on your agenda that I will see is similar to Robert's Rules of Order. Like I mentioned, Robert's Rules of Order is extremely tedious and it's meant for parliamentary procedure. If you want to see Robert's Rules in action, go watch English parliamentary discussion, and it is extremely formal. There's time limits, there's motions, there's seconds, there's votes, there's everything. Everything is all laid out there. They follow Robert's Rules. Because you are a board that is made up usually of less than 13 members, you don't have to follow those tedious, every single tiny little thing type of rules. You can follow a more informal but similar process to Robert's Rules like this one. If there's an action item on the agenda, you can make a motion to bring the item to the table. Somebody on the board will second it. Then it is open for discussion. There's usually a discussion for board members and or owners if you want to allow them. Then there's a discussion by the board itself before a vote. Then absolutely make sure that everything is recorded in the meeting minutes. Action items in particular, because these will end up being your reference points if you're ever sued for anything in the future. If you ever need or you ever want to change the agenda, you can always make a motion to do that as a board member, or even owners if they are able to get enough board members to get onto it as well. So owners and board members can make motions during an open meeting. One of the things under the open meeting law is you are required to allow owners to speak. However, you can put reasonable limitations on the amount of time that they are allowed to speak, and this usually comes in your open forum. Reasonable time limit, I mean 60 seconds, 90 seconds. If you let it drag on to like 2-3 minutes, just imagine that you have 30 people trying to do that, you're going to be stuck there for an hour and a half. So it's totally reasonable to have them go for a minute, and then if they get cut off, either they can bring it up again at the next meeting, or they can always set up a time to speak with the board one-on-one if they want to as well. So if you need to, you can always use time points in your agenda as well. So this helps keep you on track. Maybe you're only going to talk about financials for 5 minutes. Maybe you're only going to talk about new business for the first 15 minutes of the meeting. Maybe you're only going to use open forum for 10 minutes of the meeting. These are all definitely things that can help you get through your agenda. So our meetings are lasting an hour, hour and a half, not 2-3 hours, because on a Wednesday, Thursday night, the last thing we want to do is still be handling HOA business until 10 at night. So what you will typically see on a meeting agenda is, first, make sure that whoever is keeping your agenda, make sure that they have it in front of them, because it helps keep you on track. You would be surprised how many times people that are actually trying to follow the agenda don't actually have it in front of them, and they're just telling the board community manager, hey, what's the next thing on the agenda? What's this next part? What were we supposed to talk about now? The first thing you will typically do is call the meeting to order and establish your quorum. This is where you just, what that board president should have done in the previous video, he should have said, we're calling the meeting to order, we have a quorum present, and you either say what the quorum is, depending on what type of meeting. Is it a special meeting, an annual meeting, or a regular board meeting? Your quorum will either be made up of the board members or the owners, it just depends. But that's where you will establish that you either have a quorum and you're able to make decisions, or you don't have a quorum and you're not able to make decisions. So that's the calling to order. Usually you will approve your prior meeting minutes as the next point. So that's why you always need to have a record of what happened at the last meeting, so you can review it for any inaccuracies or anything that may be mistaken or typographical errors, whatever it might be. And this would be the time where you're approving those to officially get put for record keeping. The next step is typically to review your financials. So this includes any new invoices, any new income, debits, anything, all of your bank account statements. Usually the community manager will provide this for you so you can have it for the meeting. You can also address any questions, whether it be from someone on the board or somebody in the audience. Then comes the section for unfinished or old business. So this would be something that happened in the previous meeting that you had to table, and now you're going to address it. This could also be something that happened in the previous meeting that maybe you just wanted more time to speak about, so you're reserving it for this time of the meeting. This would be the time for that. Then you go on to any new business that you have to cover. Keep in mind that you can, if at any point it gets way too long and drawn out, you can table new business for the next meeting. So if you have a certain topic that maybe it's getting a little heated, you have a certain topic, maybe you need more bids, maybe you need more information before you can make a decision, table it, gather that information, make your decision at the next meeting. It's that simple. Then typically I will see the open forum, which allows all the owners an opportunity to come up and speak to the board. And then we close the meeting. So I mean, this is like a typical format that you would follow. Pretty straightforward. There is some people that will argue about when the open forum should be. We'll talk about that in a little bit. Some people will say, some people say that the open forum is better at the end because it sort of allows the board to get through everything in front of everybody. Sometimes the open forum is better fit for the beginning of the meeting because maybe somebody is there, they just want to get their 2 cents out and then they want to leave. Sometimes it's better in the middle of the meeting because maybe you want to get through the financials, and before you address new business, you want to address concerns or questions from the owners. So it all depends on your association, it depends on your community, but you can have the open forum at any point. I just recommend that you have one at some point. Okay. All right, so when it comes to meeting minutes, remember these are meeting minutes, not meeting hours. Assign somebody to be your minute taker. Usually it's the secretary. That's usually in the bylaws where it will say that that is one of their duties. Follow your agenda to help keep the minutes on track. So again, we're going off of that agenda. That agenda really does help pace the whole meeting. Use an objective voice when you're actually recording the meeting minutes. Don't include summaries of opinions. Don't include summaries of documents or presentations. Don't include how individuals voted or off the record or side conversations. So this helps to like reduce the amount of fat that we end up with in these meeting minutes. We want to only include key details like quorum, who was present for the meeting, vote tallies, how many people voted yes, how many people voted no, motions that are made, who seconded them, and then what was the vote. And then there is also a little spot reserved for anything that is notable that occurs during the meeting. So sometimes you may have something that completely off the wall happens. Maybe there was a fire alarm that triggered in the middle of it. Maybe there was somebody that was being overly disruptive. That would be the spot where you would actually put it in, would be here in those key details of the meeting minutes. Remember that these minutes are going to be shared for everybody to review. So keep in mind that you need to include the things that are important. But if you leave something out, that may be the thing that makes or breaks a case for the association if it should ever get sued, as the meeting minutes are one of the key places we go to where things were approved or not approved. It's a record of all the actions, but it does not need to be a transcript. So you don't feel like you need to catch every single thing that Sally said or every single thing that John said about the topic. You just wanted to have that a discussion was held, and then this was the action that happened afterwards. So again, open forum, I think we kind of beat that one a little bit to death. Under the HOA Act, all owners are to have an opportunity to speak. You may place a reasonable time limit. Best practice is to do it through an open forum. Is it better to have it at the beginning, the middle, or the end? I mean, that's really just up to you as an association. If you feel that you have a very contentious board meeting, maybe the beginning is better. If you feel that a board member is going to have something that you're going to address during the meeting, maybe the open forum will actually be better at the end because the question may be answered in the meeting, so you don't need to wait until the end. So it just depends, but of course, have an open forum at some point. All right, so like I've mentioned, okay, so Robert's Rules of Order, they're very tedious to follow strictly. Most documents do not require boards to follow them. If your governing documents do say to follow them, then follow them. However, there is a small board exception. So if you have less than, I believe it's 13 members, I'll have to check it. They did revise the rules. They revise them very frequently, but I believe it's under 13 board members. You can follow a more informal set of the rules like I showed in that previous slide. Just do whatever works best for your board. If you do need assistance on any Robert's rules for your board meetings, definitely let me know. Terry did share that cheat sheet on what types of motions and everything that you can call. But just to give you a sort of a hint or a view of what it looks like when people don't necessarily know what are Robert's rules of order, look at how confusing Robert's rules of order are for this board.
Cannot close question on a question that have not been asked.
I would concur with that also. So, we can't close a question on it. Is there someone who would like to make a second? There's no second on that. So no second. So motion I have.
But another motion can be brought. And that's why I introduced. Then that's why I introduced. So I'm saying, unless someone wants to make a second.
What is the motion?
It's your motion to go into executive session.
No, you have rescinded, you rescinded.
No, that's what I'm saying.
I rescinded my second.
Right, so then the person has to, is there gonna be a second?
Someone want to second that motion?
Second,
Who moved?
Mr. Gordon.
You can't move your own motion.
Mr. Gordon,
No, you can't move your own motion.
I made the motion.
Okay,
and she seconded.
Cindy seconded. Okay, she seconded.
Okay, that's good.
Jesus.
We have discussed. All those in favor?
Mr. Chair, we're still in discussion.
How can you tell? Go ahead.
So as you can see, I mean, it's so confusing that even they don't even know who's calling a motion, what is the motion about, when are you discussing, who's discussing. He made a motion to rescind. What are you rescinding? Somebody wanted to try and go into executive session at one point. Somebody tried to call a vote at one point. None of those things actually happened through that entire sequence. There was not any productive discussion. No motion was made from what I can tell. And if there was a motion, there definitely wasn't a second. If there was no discussion from what I could tell, and there was no vote. So, I mean, you can see how confusing this is for a lay person. That's why we don't necessarily need to be as strictly following these Robert's rules. If you follow the formula that I gave you in the previous slide, you will be fine. It's just getting into a rhythm with your board. And once you figure out that rhythm, you're going to be able to have a better and better board meeting. It just takes practice. Like in the beginning, it'll seem very weird, but it feels clunky at first, but it will eventually sort out and you'll get very good at it. So when it comes to board member voting and conduct, okay, board members should be encouraged to weigh in on all action items. You were elected to the board for a reason. People respect your opinion. People want your opinion to be heard. Otherwise, they wouldn't have voted for you. So vote whenever you get the opportunity. Discuss whenever you get the opportunity. The only time you should not vote is if you have a conflict of interest. So the only time you should be abstaining is if you have some sort of a benefit from it, or you feel like there's something that may cause a bias that you want the board to be made aware of. The most common example is, let's say there's a board member and let's say it's a wife and her husband owns a landscaping company. Well, if this particular association needs a landscaper and they recommend husband's landscaping company, clearly that board member can recommend the landscaper, but they need to disclose, this is my husband and I'm going to abstain from voting because I'm biased and there's a conflict of interest. So that would be the most common example. Probably not so obvious reasons would be abstaining from things that maybe you are also a party to. I've had some instances where board members have received violations and then they try to vote on whether or not their violation should be upheld. That is a point where they would abstain, or at least their vote should not be counted. Clearly, there's a conflict there. But you know, these conflicts, they come up all the time. You do have a duty to disclose them to your board. So if you feel that there is a conflict for any reason, it's better to over disclose than to under disclose. So that's my best piece of advice for you as a board member is disclose. If you feel there's a conflict, abstain. There you go. Board members with differing opinions are okay. We want healthy debate, healthy discussion. We don't want one person setting the tone or overbearing or over speaking over everyone. So this happens way too often where it feels like one person, the most common that I see is like one person who's been on the board for a long time. So they'll be like, I've been on the board for the past 18 years and this is how we've always done it and this is how we're going to continue to do it. And it's like, no, hold on. This may be a different situation. Let's hear out what this person has to say. Or just because we've done it in the past that way, that doesn't necessarily mean that that's the way we need to continue to do it. Maybe there's a better way. Maybe there's another way that we should be doing it. Maybe the law has changed and now all of a sudden there's a different way that we must do it. I mean, so board members with differing opinions are okay. Don't ever feel like you can't disagree with one of your board members, especially in open meeting. You know, like I said, you were elected to the board to represent interests of other people. They feel that you align with their opinions. They want those opinions to be expressed on the board. No matter what happens during discussion, when it comes time for the vote, remember to be united as a board around the final decision and respect the final vote. If the final vote goes a majority against you, respect the board's decision because we went through the process. Don't hold a grudge. Don't retaliate in any sort of way just because it didn't go for you this time. But at least you were able to have a healthy discussion. You were able to voice the other side and you know, respect the process itself. So, and other people will do the same for you when decisions maybe don't fall their way. Just remember, at all times, you have a fiduciary duty to act in the best interest of the association. So all of these all contribute to that. We don't want other board members to feel like they're not being heard. We don't want them to feel like they can't vote because they disagree with you. We don't want them to feel like they aren't able to state their position because maybe one board member is a little more, I want to say confrontational, aggressive, you know, more forward than the other ones. So what do you do if there is a disruptive board member or a disruptive owner present? So we kind of touched on it a little bit. It depends on how disruptive the behavior is. So if we have a Zoom meeting, the first thing I always recommend is give a warning, and you can always mute them. If they continue to be disruptive, if they keep logging in under other people, if they keep disrupting the meeting, you can kick them out of the meeting after warnings. I usually do the 3-strike rule. You give 3 strikes, you violate all the strikes, kick them out. When you're in person, this can be tricky because we're not going to, I never recommend to physically remove somebody. I don't want community managers doing that. I don't want board members doing that. I also don't want screaming matches to break out in the middle of an open meeting. Nothing positive comes out of it. No progress towards the actual meeting comes out of it. But if we are in the middle of a meeting and it's becoming so disruptive, we may need to just shut the whole thing down. And if we're at that point where we're becoming so hostile in the middle of a meeting where we have to shut it down, us as board members and community managers, we need to start thinking, is there extra proactive measures that we need to take for the next board meeting? Do we need to hire security? Do we need off-duty police present? Do we need to go to an electronic format in order to actually get our meeting done? So those are usually my ways to do it. So if you're already electronic, you can mute them, and if they continue to be disruptive, you can kick them. If it's an in-person meeting, you can give them warnings, and if it continues to be extremely disruptive, you can shut the meeting down. And if the behavior continues after that, then possibly you need to look into getting security or getting an off-duty police officer present. Sometimes we have had some instances where a manager and an owner have become so hostile with each other that one will get a restraining order against the other. So as an association, we have a duty to make sure that community managers and board members are able to perform their duties. So we may have to take steps in order to do that. Speak with legal counsel to figure out if you're actually at that point. If somebody in the community gets a restraining order against, like, let's say an attorney or let's say a community manager, that community manager or that attorney may no longer be able to attend the meeting due to the restraining order. The owner is always the first preference to go to the meeting because of the open meeting law. So if that is the case, we may need to look at, do we get another attorney or do we get another community manager to attend those board meetings? So, I mean, that's typically what I've seen as far as addressing the disruptive board member, disruptive owner present. So now we've come to the point, we've already gone through the meeting, we're ready to close. Usually a board member makes a motion to close the meeting. A board member will second that, and there's a vote. Everybody votes to close. Now is the time you go into executive session, only if you've already given prior notice. So this is something to reference back to on the notice. If you're going to have an executive session, you're going to typically have a quorum of the board. So you need to give notice of that executive session. That executive session will be closed. However, I still recommend that you give notice that you guys are coming together in executive to speak about association business. So again, this touches on the, like, is it a board meeting if you go to Jim's house and you have all the board members together? It could arguably be considered a meeting. So, and if you don't give notice, then that meeting is an invalid. Any actions taken are invalidated. So that's why I said, if you're going to meet in a quorum, do not discuss HOA business, period. just makes it easier that way, trust me. Plus, I mean, we want to keep everything as open as we can in open meeting. That's the preferred way. I mean, you all are board members, you're voluntary positions. I mean, why spend more time outside of the meeting dealing with HOA stuff when you could just reserve all of it for your meeting? Like it's a way to help you be more efficient, because you're like, okay, we have things that we have to get done today. And then it keeps like discussions from being drawn out into super long email threads or being drawn out for like 5 meetings. Like eventually you're going to have to deal with the thing, but continuing to have an email thread going back and forth. Please do not text each other regarding HOA business, goodness. Which brings me to the next point here. Anything that you use as far as communication will be discoverable if the HOA gets sued at some point. Meaning that if you have an email, your personal email that you're also using for HOA business, and the association gets sued and there's a question about something that was said over email, all of your emails will get turned over to counsel. Does the opposing counsel get to put those into the record? Probably not. I will have to actually do an evidentiary hearing on what is actually relevant to what we're talking about. However, I have seen some cases where a personal email or a personal cell phone is used, and maybe a husband and wife are sending boudoir photos to each other. Those are now discoverable, and I have to go and exclude them. So now not only have I seen them, but now opposing counsel has seen them. There's also possibly the opportunity for the judge to see them to make a determination. So anything that is regarding HOA business, you should keep it completely separate, because we want to make it more efficient if we ever have to actually disclose all of this stuff. But we also don't want all of your personal items to be intermingled with all of them, and then we have to separate all of them out. So in my opinion, best way to conduct business is do it through an email that you created specifically for the HOA, and try to keep all of your communications limited to the actual board meeting, or try to limit it to like scheduling, things like that. So that brings me to the next topic here. What about email communication? So we touched on the open meeting law. Like, what happens if you have people showing up in a quorum and they're discussing HOA business? Well, email is sort of in the gray area. There hasn't been a solid answer given yet. Nationwide, the trend is that these are considered meetings. If you look at the HOA statute, and then if you look at the New Mexico HOA Act, as well as the Nonprofit Corporation Act, you can make decisions in writing through a unanimous consent, and usually that's done through email. So the trend nationwide is that these meetings on email are being construed as almost similar to meeting at Jim's house, meeting at John's house. So in my opinion, my recommendation is don't do it. I mean, my opinion, many boards use email way too much. You're emailing every single day about every tiny little thing. You're emailing about the landscaper. You're emailing about violations. You're emailing about what happened at the last meeting. You're emailing about financials, about meeting minutes. Don't put anything in an email that you wouldn't want disclosed to opposing counsel or to potentially to a court. Of course, like I said, I would be able to exclude some of that from evidence, but that doesn't mean that it's not going to be disclosed first and people are going to see, read, whatever it is that you put together. Which also brings it to which also makes me want to remind you that if you have an opinion about somebody in the community, the worst place to voice that opinion is in an email or a text, period. It's just don't do it. Don't do it. So, like I said, these email communications that usually happen between the board members, they're not a meeting as defined by the statute in the HOA Act or the Condo Act. However, there is that trend that if you're meeting together and you're discussing HOA business, potentially that might be considered a meeting. Like I said, try to limit all of those email communications to only things that require the unanimous written consent action outside of a meeting standard, or some sort of an emergency, or like a scheduling for meetings, or something that's not necessarily discussing HOA business or making decisions. Like, limit your email communications. It'll give your attorney a sigh of relief in the event that you ever do end up getting sued. Try to conduct most, if not all, of your business in open meeting. Like I said, you're a volunteer. You're already spending a lot of time during the meeting, during the week, to actually deal with HOA stuff. Don't draw it out and make this a part of every single day life. This is This is not something that we want you to be thinking about 7 days a week. We want you to be able to live your life. And then when it comes to actually time to doing the meeting, that is the time that we've reserved for you to actually handle your meeting, if that makes sense. So that is all I have for you today. I saved you 5 whole minutes. If you have any other questions, hopefully this was informative. Like I said, I mean, I never attended a board meeting, and I would imagine that prior to anybody actually getting on an HOA board, they probably hadn't attended one either. So these are all of the tips and all of the things that I have seen in my 4 years of practice and attending board meetings. I've attended some that are very hostile. 95% of the meetings that I attend are not. They are very good. Usually everybody is very hospitable with each other. Like I mentioned, I mean, if a board is doing things that are making the community upset, usually there's a lot of people present and they want to make their voice heard. If people are generally happy with what you're doing, they're not showing up to the board meeting to tell you that. So if you're not getting a lot of people at your board meeting, it's not necessarily a terrible thing. Maybe they just agree with everything that you're doing and they don't see necessarily, extra oversight is needed. But at the same time, I mean, it always helps. We could always make our meetings shorter, which I think the managers will appreciate, as well as the board members. And if you ever have an issue come up where you need me to actually attend a meeting for you, definitely let me know. Shoot me an email. Terry has all of the slides as well as the Robert's Rules of Order cheat sheet that we put together. So definitely send her an email if you would like a copy of that. If you are a community manager or a board member, I don't know if we still have very many New Mexico statute books, but Terry would be the person to contact so we could get you one of those if you need one. Other than that, are there any questions from anybody here? I saw Brandy came in a little bit late. How are you doing, Brandy? Courtney, thanks for attending and thanks for being present for all this. I appreciate it. Laura, I appreciate the comments on there, especially with that video that came on. It was hard actually finding videos. I guess probably when somebody gets recorded on YouTube, they probably do anything they can to get it removed. I did, so that first video that I put, it said there was a part 2, but the part 2 was actually removed because it said that it violated terms of service for YouTube. So I don't know what happened in that part 2 of that meeting. I could only imagine. The good news is I haven't actually had a very contentious one like that in New Mexico yet, knock on wood. But oh, you're all good, Brandy. Don't even worry about it. I'm sure Terry's already recording this, so I'm sure she's going to post it. Terry, where are we going to post this afterwards?
On the YouTube site, and that is, I can put a link. I'll put a quick link in the chat.
Sounds good. Like I said, I mean, there was one of the directors of one of the management companies asked me to put this whole presentation together. Clearly, I want to make it available for everybody so that way they could reference back to it if they need to. And always, if you need to follow up with an email to me, like I said, if you need me to attend a board meeting for you, if you need me to address any questions that you have, whether it be like Robert's Rules of Order or what kind of notice that you need for your meetings, anything like that. If you're dealing with a disruptive homeowner or a disruptive board member and you feel like they're making your job more difficult than it has to be, definitely reach out to me so we can see if there's something we can do about that. Other than that, I mean, we're right here at 1 o'clock, so I think I'm gonna let everybody go unless you have any questions. It doesn't even have to be related to the board meetings. It could be about anything. I mean, I'm here for you. It's like an office hour. All right. Well, I mean, I'm not seeing anything in the chat. Oh, perfect. Yeah, for sure, Laura. Go ahead, email me, and yeah, anything that you need, just let me know. But yeah, if you need copies of the slides, if you need copies of the Robert's Rules of Order, I don't have the actual Robert's Rules of Order. They sell it. It's like, I think it's like 25 bucks. But like I said, I mean, I don't think boards necessarily need to have the entire Robert's Rules because they're smaller boards and there's an exception for them. So, I mean, if you have somebody that is very parliamentarian and they really want you to follow every single one, if it works for your board, it works for your board. But you know, at the same time, I'm not going to force every single one of the boards that are my clients to actually follow it to the T. It's just way too much. It's just way too tedious. So, all right then. Well, I hope everyone has a good day.